Hey guys, welcome back. I just got back from Los Angeles after hanging out with my buddy, the IA guy. This is going to be episode 25. The episode we're going to discuss qualified immunity. It is a very misunderstood thing. So I'm Don. This is the conditions report. And if you've already been listening to the show, well, then you know the premise. And if you're new here, well, here's what you need to know. This is the weather forecast for street cops, detectives, and admin. What's coming up, what's changing in the environment that we work in. But before we go any further, a quick disclaimer. I am not an attorney, and nothing discussed on this show should be considered legal advice. I'm not speaking on behalf of any government agency or law enforcement agency, and the views expressed here are those of Forecast Securities Group and myself, and they're an exercise of protected American free speech. If you need legal advice or guidance, specific to your agency or jurisdiction, you should consult qualified legal counsel. This podcast is for educational and informational purposes only, and we're not here to judge officers involved in incidences or to second guess the decisions with the benefit of hindsight. The point is to learn from their hard earned lessons on our behalf and improve as a team. In this episode, we're going to discuss the Supreme Court's per curiam decision handed down on March 23rd, 2026 in Zorn v. Linton. The case centers on a Vermont State Police sergeant who used the standard rear wrist lock during a arrest of a passively resisting demonstrator inside the state capitol rotunda on inauguration day 2015. The court reversed the Second Circuit and held that the officer was entitled to qualified immunity because no prior precedent had clearly established that his precise conduct violated the Fourth Amendment. This ruling comes at a moment when the doctrine itself is under a sustained public and legislative pressure, yet remains one of the most practical shields officers carry in the street. For working patrol officers, it clarifies the notice requirement that protects reasonable split-second judgments when the law is unsettled. And for detectives and administrators, it underscores the importance of training and documentation that anticipates appellate review. The episode matters because qualified immunity is not a license for misconduct, but a constitutional safeguard rooted in fairness and notice. The constitutional stakes are straightforward. Officers must be able to act without fear of personal damage liability when the legal rule at the time does not give them fair warning that their specific actions could cross a line. So here's the situation brief. The story begins on a cold January morning in 2015. I know, a long time ago, inside the Vermont State Capitol in Montpelier. It was inauguration day for Governor Peter Shumlin, and the building was filled with the usual mix of dignitary supporters and a small group of protesters who had gathered to voice opposition to state policies on a range of issues, including energy and criminal justice reform. About 200 protesters attended, and some of them staged a sit-in to demand universal health care. Shela Linton joined them, and she planned to refuse to leave and anticipated being forcibly removed. This is the point of the sit-in part of the protest, she later explained. When the Capitol closed to the public for the night, 29 protesters remained in the legislative chamber, sitting on the floor with their arms linked. At that point, police officers explained that they would arrest the protesters for trespassing if they did not leave, and the officers dealt with them one at a time. Some stood up and were escorted out of the chambers without force, but others refused to stand and had to be lifted to their feet or drug out. After removing more than a dozen protesters, the officers turned to Linton. Sergeant Jacob Zorn crouched down to speak with her, but she remained seated with her arms interlocked with those of her fellow protesters. As Linton passively resisted, Zorn unlinked her arm from another protester's arm and put it behind her back in a rear twist lock. He then twisted her arm, and Linton exclaimed, "Ow, ow, ow, ow," while Zorn repeatedly implored her to please stand up. After Linton responded, "I will not stand up," Zorn told her that he would not ask her one more time and that then he would use more pain compliance. Linton refused, so Zorn placed pressure on her wrist and lifted her up by her underarm. Linton yelled as she stood up, but once on her feet, she continued to jerk her arms and fell back to the floor. Zorn asked her to stand up again, and when she did not, 3 officers picked her up by her arms and her legs and carried her outside. Linton would later allege that the resulting physical and psychological injuries included permanent damage to her left wrist and shoulder and post-traumatic stress disorder. Several months afterwards, Linton would file a civil rights lawsuit under 42 USC Section 1983 in a federal district court alleging that Sergeant Zorn used excessive force in violation of the Fourth Amendment. Discovery revealed that body-worn camera footage and deposition testimony captured every step of the encounter. The district court granted summary judgment to Zorn on a qualified immunity grounds, concluding that it was not clearly established at the time of the encounter that these circumstances of lifting Linton while putting pressure on her wrist would violate the Fourth Amendment. Linton appealed to the Second Circuit, and in a divided panel opinion, the appellate court reversed. The majority relied on its own 2004 decision in Amnesty America versus West Hartford, which had involved a different protest scenario and had sent the case back for a jury to decide whether force was gratuitous. The Second Circuit held that the precedent clearly established that the wristlock was unlawful under the facts presented. The case would then travel to the United States Supreme Court on March 23, 2026. The court issued a 6-page unsigned per curiam opinion reversing the Second Circuit and directing that qualified immunity be granted. The opinion emphasized that the Second Circuit had misapplied the specificity requirement and that Amnesty America had never actually held any officer's conduct unconstitutional. 3 justices dissented, arguing that the majority's approach was too narrow and that the circuit precedent should have put a reasonable officer on notice. The factual record developed over an 11-year period of litigation showed no evidence of malice or rogue behavior, and Sergeant Zorn followed training policy and his own experience. The encounter was brief, documented, and consistent with the mission of clearing the public building while respecting the right to protest. And the courtroom testimony from training officers confirmed that the rear wristlock was an extremely low-level control technique taught precisely for situations involving passive resistance where higher levels of force would be disproportionate. The emotional context was human on both sides. Linton described feeling pain and humiliation during the arrest, and Sergeant Zorn testified that he was focused on the safety of everyone in the crowded rotunda and on avoiding escalation that could have injured other people, protesters, or officers. Now imagine yourself as the sergeant on that night. You have given clear, repeated warnings. You're using a approved technique in policy, drilled into you from the academy. The protester is passively resisting, but the situation is not violent. And yet years later, a decade to be precise, you're still defending yourself in a lawsuit that could have reached into your personal finances. And that's the real world pressure this case brings home to every officer who's ever had to move someone who simply will not comply. The current conditions are this. The qualified immunity doctrine under 42 USC 1983 and federal constitutional tort law shields officers or government officials from damages or liabilities unless they violate a clearly established constitutional or statutory right and that a reasonable official would have known. Many people today view this doctrine as bad or unnecessary. Critics argue it creates a shield that lets officers escape accountability, even when citizens are harmed, that it makes it too difficult for a plaintiff to win a civil lawsuit, and that it perpetuates a sense of impunity in law enforcement. And some see it as an outdated relic that no longer fits a modern society with body-worn cameras and widespread video evidence. Those critics are heard loudly in public debates, legislative proposals, and scholarly commentary, and they deserve to be taken seriously. Yet to understand why the Supreme Court has repeatedly reaffirmed this doctrine, including the March 23, 2026 decision in Zorn, we need to trace its foundations from the beginning. The idea of official immunity is not a modern invention. It draws from centuries-old common law principle that protects public servants from personal liability, so they could carry out their duties without constant fear of ruinous lawsuits. I mean, think of it this way. A lot of the instances that these officers are involved in, they would never be involved in if it weren't for their employment as police officers. Right? I don't think Sergeant Zorn as an individual would have been in the rotunda trying to clear people out of there if it were not for his employment. And that's kind of the crux of the issue, is oftentimes the employment interjects officers into situations that they potentially would have never been in had it not been for their job. In the American constitutional system, the courts first applied this form of qualified immunity to police officers in Pearson v. Ray in 1967. It recognized that officers acting in good faith under the law, as it was understood at the time, should not face damages even if later courts viewed their conduct differently. And the modern formulation arrived in Harlow v. Fitzgerald in 1982. There, the court held that government officials performing discretionary functions are shielded from liability unless their conduct violates clearly established statutory or constitutional rights of which a reasonable person would have known. The purpose was practical, to protect officers from the burdens of litigation itself, but not merely from the ultimate liability, so they could make split-second decisions without the constant threat of personal financial ruin. In Saucer v. Katz in 2001, the court required that judges to address the constitutional violation question first before turning to the clearly established prong. Then, in Pearson v. Callahan in 2009, the court gave lower courts flexibility to decide which prong to address first, precisely to spare officers unnecessary litigation when the clearly established inquiry resolved the case. Over the years, the court has emphasized that the right must be defined at a high level of specificity, as it again reiterated in the case Mullenix v. Luna, so that every reasonable officer would understand that what he or she is doing violates that right. This is not the doctrinal foundation the court applied in Zorn v. Linton. Sergeant Zorn's use of the rear wristlock after repeated warnings did not meet the threshold because no prior case had even held that this exact sequence of events was unlawful. The Second Circuit's reliance on a more general principle from a 2004 Amnesty America case decision was not enough. The per curiam opinion made it clear that the specificity requirement remains at the heart of the doctrine. It is not a blanket immunity for all government misconduct, but it is a defense that protects officials from damages when the law is not clearly established at the time of the conduct. The Supreme Court has repeatedly said that qualified immunity is an immunity from suit, not just a defense to liability, and therefore courts should resolve early, such as summary judgment, whenever possible. The common misunderstanding persists, and it's important to separate myth from reality in plain terms. Some say qualified immunity lets officers do whatever they want, but the truth is it does not protect conduct that violates clearly established law. And others claim it's only for police officers, when in fact, it applies to many executive branch officials, including school administrators, teachers. The idea that if constitutional violation happened, the plaintiff automatically should win overlooks the second prong of the suit entirely. The plaintiff must overcome both the violation question and the clearly established law question. The notion that qualified immunity means no one can ever sue is also incorrect. It does not bar suits against the government entirely under the Monell Doctrine or against officers for injunctive relief. It simply bars damage claims against individual officers when the law is not clearly established. And people will often confuse qualified immunity with protection from criminal prosecution. But the truth is, qualified immunity is strictly a civil defense in damage actions under 42 U.S.C. 1983 and offers no shield whatsoever against criminal prosecution. If the conduct violates criminal law, then they can be prosecuted. And finally, the doctrine is not only about the merits at the end of the case, it's procedural as well because it protects officials from the burdens of litigation itself. Scholars have offered legitimate criticisms of how the doctrine operates in practice, noting that it can sometimes shield conduct that feels intuitively wrong, or that it may reduce incentives for agencies to improve training. And those critiques deserve serious discussion, but they do not change the state of the legal standard that the Supreme Court has set repeatedly. What the Zorn ruling does is remind every agency that the best protection against liability is not rhetoric, but it's the kind of specific scenario-based training and meticulous documentation that allows officers and supervisors to show exactly why they believe their conduct was lawful at the time. Picture yourself on the stand 10 years from now, explaining why you used a taught technique after giving warnings. Qualified immunity is the reason that testimony can focus on the reasonableness of your actions in the moment, rather than whether a later court might have preferred a different approach. Constitutional principle reaffirmed by the court's straightforward. The constitutional principle reaffirmed by the court is straightforward. Qualified immunity exists to give fair notice and to protect reasonable official action when the law is not settled. In 2026, with body worn cameras, viral videos, and evolving protest tactics, this principle remains one of the most practical tools officers and leaders have to navigate the line between authority and accountability. As we move from the legal analysis to the leadership implications of Zorn, it's worth pausing to recognize how crowd control and protest management tactics continue to evolve across the country. Departments are facing more frequent sit ins, demonstrations, takeovers, and acts of civil disobedience in which individuals will deliberately engage in passive resistance. The facts of this very case, a peaceful but determined occupation of a state capitol rotunda, illustrate the difficult environment officers now regularly encounter. The Supreme Court's decision underscores a critical distinction between passive resistance and active resistance when determining the appropriate level of force. Officers must remain disciplined in verifying that the techniques they use, such as the rear wrist lock applied here after repeated warnings, are not being used as an intermediate level of force against subjects who are simply refusing to comply without posing any safety threat. Getting the distinction right and the type of force right is important, and being able to clearly articulate afterwards why you use what force you use remains one of the most practical challenges in modern law enforcement. That brings us to the leadership navigational aid. The Constitution is not a suicide pact, but neither is it a blank check for unchecked power. And those words came distilled from Justice Robert Jackson in a dissent in Terminelio versus Chicago in 1949. In that case, the court overturned a conviction for disorderly conduct after a speaker at a packed political rally delivered inflammatory remarks that nearly triggered a riot outside an auditorium. Jackson warned that interpreting the First Amendment in its absolute terms could allow speech to destroy the very order the Constitution exists to preserve. He was not calling for censorship. He was instead insisting on a balance. Constitutional rights must be protected, but they cannot be turned into a suicide pact that leaves society defenseless against chaos. At the very same time, he reminded us that government power is not a blank check, that the same measured balance is why qualified immunity exists and why it's essential for every street cop who must make split-second decisions under stress. The doctrine does not give officers a free pass. It simply requires that the constitutional rule they allegedly violated was clearly established at the time and with a high degree of factual specificity that would have put any reasonable officer on notice. When that specificity is absent, qualified immunity steps in to protect officers from personal liability. The protection is not theoretical. It's a practical shield that lets officers act decisively in uncertain, rapidly unfolding situations without paralyzing for fear that a later lawsuit could cost them their house. And many officers still believe that if they're sued, they will lose their home. The rumor is persistent, but it is false. When qualified immunity applies, once the court grants the shield, personal assets are generally protected. And the suit may proceed against the municipality, but the individual officers are often shielded from financial ruin that critics often claim is inevitable. And qualified immunity operates as a gatekeeper that resolves these cases early, sparing officers the burden of discovery, trial, and when the law is not clearly established. And this is why the doctrine is not a relic. This brings us to the single leadership principle. Supervisors carry the responsibility to move training beyond slogans like use minimal force necessary and into concrete scenarios, instruction-based, that teach officers how to recognize when the law is clearly established versus when it's not, and then how to articulate and document exact facts that justify their split-second choices. Picture a patrol officer on a routine traffic stop at 2 a.m. who encounters a driver who refuses to exit a vehicle and sits passively with his hands on the wheel. The officer issues clear repeated commands and then applies a standard wrist lock technique taught to him in the academy to assist the driver out of the vehicle. Later, that driver sues, claiming excessive force. And often, another misconception is that if a constitutional violation happened, the plaintiff will automatically win. Yet the doctrine requires that the plaintiff overcome both the violation question and the clearly established inquiry, and also the court could skip straight to the second prong under Pearson v. Callahan, sparing the officer the burden of a full trial. In another scenario, imagine a school resource officer breaking up a fight in a hallway between two students who are passively resisting separation. The officer uses the same wristlock technique Sergeant Zorn used in the Capitol Rotunda. A lawsuit follows, and the misconceptions arise that qualified immunity is only for police officers. The truth is, the doctrine reaches many executive officials, including school administrators and teachers, and the court would apply the same high levels of specificity from Mullenix v. Luna, requiring precedent that placed this exact hallway use beyond debate. Many officers worry that if they get sued and they lose qualified immunity, they'll lose their house. Or they think that simply following department policy will automatically secure qualified immunity. The fear is understandable, and after years of headlines and locker room talk, the reality is far more reassuring. Even in the rare instances when qualified immunity is denied and a case moves forward, officers almost never pay out of pocket. Extensive research by Professor Joanna Schwartz, who examined more than 9,000 civil rights settlements and judgments across dozens of the nation's largest and smallest agencies, shows that governments and their insurers satisfied 99.98% of all dollars recovered by plaintiffs. Officers personally contributed in only about 0.4% of those cases, and their total share amount is just 0.02% of all the money paid. In a practical term, it means that the department or the city writes the check in virtually every instance. Even when indemnification is technically prohibited by policy or when the officer is disciplined or criminally investigated, the house stays safe because of things like indemnification, not qualified immunity alone. It's what ultimately protects personal assets. Picture a sergeant who loses qualified immunity in a use of force case because the appellate court finds that the law was clearly established. The jury returns a verdict and the parties reach a settlement. The officer does not refinance the mortgage or sell the family home. The municipality indemnifies just as it does in the overwhelming majority of these matters. And the department policy remains an important aspect because it keeps officers aligned with best practices and reduces overall risk, but the policy is not the measuring stick for qualified immunity. That shield turns on whether the constitutional rule was clearly established at the moment the decision was made. So the department can have policy sometimes that is out of date and advises officers to make decisions that are in conflict with case law. Officers and supervisors who train with specificity learn to document warnings given and the exact technique employed, the lack of higher force options, and the safety rationale in language that survives appellate review. When leaders fail to build that habit, officers and supervisors who train with specificity learn to document the warnings given, the exact technique employed, the lack of higher force options, and the safety rationale in language that survives appellate review. When leaders fail to build that habit, they leave their people navigating the hallways and highways with no clear lines at all. And this principle connects directly to qualified immunities framework. Harlow v. Fitzgerald established the modern shield so officials performing discretionary functions are not subject to personal liability. Pierces v. Callahan gave courts flexibility in the two-prong analysis and protected officers from unnecessary burden. Zorn now stands as the latest reminder that the circuit precedent must be applied with factual specificity, not a broad brush. And James Madison warned in Federalist Number 51 that in framing a government, which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the governed, and the next place is to oblige it to control itself. Madison reminds us that power, even the power to hold officers accountable, can sometimes wear the mask of public good. Leaders therefore carry a solemn responsibility when they exercise authority over training, policy, and discipline. They must never allow institutional pressure or public outrage to substitute vague expectation for the precise constitutional notice that qualified immunity demands. And we must train with specificity, document with precision, and lead with intellectual honesty about what the law actually requires in the moment. On a practical note, many officers maintain personal liability insurance or umbrella policies as an extra layer of protection, and consult financial professionals about how to structure assets in asset protection strategies such as revocable trusts. These are personal decisions best discussed with a qualified advisor, but they reflect the reality that a prudent officer prepares thoughtfully, even when relying on the strong protections already provided by law or agency. In the extended forecast, looking ahead, similar qualified immunity questions will continue to arise as protest tactics evolve. Body worn camera footage becomes the default record, and public scrutiny intensifies. Technology will capture more encounters in real time, raising the bar for factual specificity in reports and training. Evolving legal doctrine may see further legislative attempts to modify the doctrine, but the Supreme Court has signaled repeatedly that any changes must respect the notice and fairness principles at the core of Harlow and its progeny. Institutional pressure from viral videos and community expectations will test leaders who must resist the temptation to overcorrect policy in ways that chill lawful enforcement. And officers and administrators should continue to rely on careful judgment, constitutional discipline, and thoughtful scenario based training that anticipates these appellate fights. The environment remains demanding, but the best defense against uncertainty is the same discipline we talk about on every single episode: researching case law, knowing the circuit you're working in, knowing what your authorities are, and being able to articulate evidence gathering when operating near the line between authority and liberty. It will remain the surest way to protect both public safety and individual rights. As we close, let's remember the point of the show is not to pass judgment or to revisit decisions with the benefit of hindsight. It's to learn as a team and improve. We're all leaders, so keep the leadership navigational aid in the back of your mind. The work is complicated and the environment is demanding, and none of us get it perfect. So stay hungry, stay humble. I'm Don, and this has been the Conditions Report. Be the calm in the storm, the clarity in confusion, and always influence the weather.